In today's episode, we explore a groundbreaking legal case in Switzerland where the European Court of Human Rights addressed the intersection of climate change and human rights violations. We analyze the arguments presented in the case and the court's evaluation of their claims, highlighting the significance of establishing governmental accountability in climate policy. We also discuss the broader implications of the ruling for global climate justice and human rights protection and offer insights into the actions governments, including Switzerland, must take to mitigate climate change and safeguard the rights of all citizens. My guest today is Saab, Associate Professor in International Law here at the Institute. Welcome to the What Matters Today podcast from the Geneva Graduate Institute. I'm Dan Graham, Head of Communications at the Institute. In this podcast series, we ask members of our faculty to comment on key global issues. So thanks, Sam. Thanks very much for being part of this podcast episode. I'm going to just jump in with the first question. Can you provide some background on the landmark case decided by the European Court of Human Rights regarding climate change and human rights violations in Switzerland?
Yes, absolutely. So in August of 2016, a group of senior Swiss women created an association which they called the Senior Women for Climate Protection Switzerland. It initially counted 40 members, and by November of 2016, the association already had 500 senior Swiss women who were a member of that association. And they submitted a legal request to the Federal Department of Environment and some other Swiss departments. And their main claim was that Switzerland is not doing enough to take action on climate change and that this is violating their human rights. The focus here is on the fact that these women are senior, which is defined as 65 years or older. It depends on how you define what senior means. And that those women are particularly vulnerable to, for instance, the heat waves, increased frequency of heat waves, and that has an adverse impact on their health. Their first request was dismissed in April of 2017, and then they filed an appeal to the Federal Administrative Court in May of 2017. This appeal was dismissed in December of 2018. And then they finally made an appeal to the Swiss Federal Supreme Court in January of 2018. And the Supreme Court dismissed their appeal in May of 2020. So in May of 2020, the Supreme Court of Switzerland, that was the final instance, made their decision that their case was dismissed. And it's important to note, so an important criteria for admissibility for applications before the European Court of Human Rights is that domestic remedies have been exhausted. So in this case, this Swiss Association of Senior Women, they exhausted all the domestic remedies within Switzerland up until the Supreme Court, which rejected their case. And then after this, in October of 2020, the association announced that they would be bringing their case before the European Court of Human Rights. Now, the European Court of Human Rights is responsible for ensuring the protection of human rights as stipulated in the European Convention of Human Rights. And all 46 member states of the Council of Europe are parties to the European Convention on Human Rights, including Switzerland. So in this case, it was both the association, so the Association Senior Women for Climate Protection Switzerland, as well as a number of individual applicants who brought their case before the European Court, arguing that Switzerland is not upholding their obligations to protect their human rights. The actual application was submitted to the court in December of 2020, and then several things happen after that. After the official application is submitted, the Swiss government responded in writing, so they gave their response. Third-party interventions were written in writing, so that included national and international organizations who are focusing on environment, on human rights questions. And then public hearings were held in March of 2023. And those are available. You can hear those public hearings. Then, which is the reason why we are talking about this case today is that on the 9th of April of 2024, which is just over 3 weeks ago, the European Court of Human Rights made its final judgment in this case and ruled in favor of the applicants and against the Swiss government. And it's maybe important to note that by April 2024, the membership of the association is over 2,500 members. So that's a bit of the background.
What specific arguments were presented by the group of senior Swiss women in this case, and how did the court assess the validity of their claims?
Yeah, so there were 3 main complaints that the association and some of the individual litigants, applicants made. In this case, the first complaint is that Switzerland does not have adequate climate policies and is therefore violating the women's right to life and right to health under Articles 2 and 8 of the European Convention on Human Rights. So the first claim is really the most substantive claim. Then the second main complaint that they have is that the Swiss Federal Supreme Court rejected their case based on arbitrary grounds, so that the Supreme Court didn't substantiate their reasoning for rejecting their case in the final instance, and that violates their right to a fair trial, which is stipulated in Article 6 of the European Convention on Human Rights. And the third main complaint is that the Swiss authorities and the courts did not deal sufficiently or adequately with the content of their complaints, and that this violated their right to an effective remedy, which is stipulated in Article 13 of the European Convention on Human Rights. It is important to note that the European Court of Human Rights granted standing to the association, but did not grant standing to the individual applicants in this case. And I think that's a very important point to make. It is very, very difficult for an individual to demonstrate that they are directly and personally affected. And so therefore, it is usually a good idea in these cases to bring a claim as an association. So in this case, it was the association that had standing and not the individual applicants. So I think there are many things that happened in this case. The judgment is 250 pages long, and there will be years when various complex parts of this judgment are going to be assessed in much detail. But the most important, and I think what has received the most attention in terms of the judgment, is that the court found that Switzerland had violated their right to respect for private and family life under Article 8 of the European Convention. So really part of that first main substantive claim. And the court explained that Article 8 encompasses a right to effective protection by state authorities from serious adverse effects of climate change on lives, health, well-being, and the quality of life. And what the court said is that Switzerland has committed itself to various international obligations under climate change law, under human rights law, but has not done enough to meet those obligations.
How significant is this ruling in terms of establishing a legal precedent for holding governments accountable for their climate policies and their impact on human rights?
Yeah, so the judgment is most directly relevant for Switzerland. Switzerland is the state that was brought before the European Court of Human Rights. It's important to emphasize that the judgments of the European Court of Human Rights are legally binding, and so therefore the states involved have an obligation to comply with the judgment. So this is very, very important for Switzerland. It's legally bound by this judgment and so has to comply with what the European Court has said. But it's also important to note that the court leaves a margin of appreciation for states. So it is not for the court to make climate policies. It is not for the court to say, this is what Switzerland needs to be doing in terms of its climate policies and in terms of its human rights protection. But it is for the court to say, this is what Switzerland has committed itself to. And so these are the legal obligations that Switzerland itself has committed itself to, and so needs to comply with those obligations. And has also, in terms of human rights obligations, has bound itself to the European Convention on Human Rights. So I think the important, in terms of what Switzerland has to do, Switzerland will have to make sure that it takes sufficient action to address climate change. But it is not for the court to decide how Switzerland does this, but that they do something. Of course, the ruling has wider repercussions, not only for Switzerland. So all parties to the European Convention on Human Rights are bound by the same human rights obligations. And so therefore, this judgment is likely to serve as an opening for more cases brought before the European Court against other states that are party to the European Convention on Human Rights as well. I think it is important to note, though, that even though this is a very important judgment and it really has implications beyond Switzerland, that the particularities of the Swiss context do have to be kept in mind. So I would say that most European countries, they either already abide by the minimum requirements that the court has asked of Switzerland, or they are in the process of getting climate laws and policies that abide by those regulations. So it is really important to note that this is a Swiss context. This case worked in the Swiss context, but if a case would be brought against another state before the European Court on Human Rights, it would have to rely on a different context and somehow different arguments. But even without or before application, like new applications are brought before the European Convention on Human Rights or before other courts that draw on this case or on this judgment, it is clear, and I think this is really the most important part of the judgment, is that the court has made it very clear that climate change is a human rights issue and that climate change has impacts on human rights. I think that was already recognized, but not in a court of law in this way. So now the European Court on Human Rights says the implications of climate change are human rights issues, and a human rights court has something to say about this, and states have positive obligations to ensure that they are doing enough to protect human rights implications of climate change.
In your opinion, what are the broader implications of this ruling for other countries and regions facing similar challenges in addressing climate change and protecting human rights?
Yeah, so I wanted to maybe start off that I can address that question by saying something about what climate change litigation is for. So there are various functions of climate change litigation, and the most obvious function is the legal function. And that, as I responded to the previous question, this judgment is most directly relevant for Switzerland and for other states that are parties to the European Convention on Human Rights. But there are broader implications for other climate litigation cases beyond Europe and beyond this particular court. So for instance, at the moment, there are hearings ongoing in a request for an advisory opinion before the Inter-American Court of Human Rights. So Chile and Colombia have made a request to the Inter-American Court on Human Rights for an advisory opinion, which asks in particular the Inter-American Court on Human Rights to define the scope of states' obligations in relation to climate change. For instance, what is the scope of states' obligations to the duty to ensure a right to a healthy environment? This judgment by the European Court will be read with much interest in the Inter-American Court on Human Rights, and there is actually already a long history of the European Court on Human Rights and the Inter-American Court on Human Rights really influencing each other on cases that relate to environmental matters more broadly. So surely this case will be very relevant for the ongoing case before the Inter-American Court on Human Rights. Beyond specifically Human Rights Court, there is also an advisory opinion currently that has been requested from the International Court of Justice. And I expect that the International Court of Justice is also going to be taking note of this judgment by the European Court on Human Rights. And I think here it's important to mention that this case of the European Court on Human Rights is specifically a human rights case by a human rights court. So it looks explicitly at human rights obligations of Switzerland in this case. And the Inter-American Court on Human Rights also looks specifically at human rights obligations. But human rights have become central to climate change litigation more generally. So even those cases that are not brought before human rights courts and that are not specifically focusing on human rights, they almost always have human rights components in there as well. So this case is going to be very relevant, and the particular ways in which this case was argued is going to be very relevant for other cases as well. And then maybe the last thing I wanted to say here is that I started off with saying there are different functions of climate litigation, and the first is this legal function. But there are a lot more functions of climate change litigation. So litigation also has a very powerful strategic function. And I think especially high-profile cases such as this Swiss case before the European Court of Human Rights really serve as an extension of climate activism. And even cases that might fail in terms of legal outcomes still have a lot of value. What you will see is that some lawyers will really be delving into the particular legal details of this case. But we have seen this case in the media. There's an incredible media attention for this case and for other landmark cases in climate litigation. And you can see that that fits part of the development of climate change litigation. There's so much attention for it. So this case is really, really important, and it has broader implications just for connecting climate change to human rights and for emphasizing that states in this case really cannot, on the one hand, commit themselves to climate obligations, to human rights obligations, but on the other hand, not do anything, to actually realize those commitments.
And my last question, moving forward, what actions do you believe governments, including Switzerland, should take to mitigate the effects of climate change and ensure the protection of human rights for all citizens, especially the most vulnerable groups?
Yeah, so that's a great question. And I have to admit, I can't really answer that question. And the reason why I can't answer that question, it goes back to a point that I mentioned earlier in this conversation, which is about what is the function of a court in these cases. And this is really one of the biggest controversies or issues of debate within climate change litigation, is this question of what can a court do and what should a court do. In this case, there was one dissenting opinion. So one of the judges who did not agree with this case and has written out in why they did not agree with this judgment. But if you look at how this judgment has been received within Switzerland, there's quite a lot of critique saying, well, the European court, has overstepped what it can actually do, has overstepped its authority. It's not for a court to say what kind of climate policies the state should take. And you really see this dynamic in a lot of climate litigation cases, not only before the European court, but really in a lot of the climate cases where you see that the pushback is, well, is this what a court of law should be deciding? They shouldn't be deciding on climate policies. So if you ask what should governments do, it certainly is not for the court to decide what kind of policies they should take. But to stick with the particular case, I think the European Court of Human Rights has not told Switzerland how their climate policies should be and how their policies should take shape. They have said, you have committed yourself as a state to these legal obligations, and you need to at least show that you are doing something to meet those legal obligations. So I think at the very least, what governments should do is follow the obligations that they have committed themselves to. But that's where it gets, of course, very complicated, because states commit themselves to many obligations at the national level, at the international level. And even if we stick to human rights obligations alone, human rights are very varied. There are many different human rights. There are many different people, and they all have human rights. And human rights are also often contradictory. Right. So if you take, for instance, in this case, senior Swiss women have made successfully their case that they are particularly vulnerable to the impacts of climate change. Yeah. But of course, a lot of the commentary that I've seen already says, well, senior Swiss women, are those really the vulnerable groups? There are many vulnerable groups, and there are many arguments that can be made, but that might sometimes also be contradictory. So protecting rights of one vulnerable group might not be in favor of protecting other human rights of other vulnerable groups. So what I would hope is that this case really serves as an incentive, and this is really how the applicants had intended this case to be. It was not their intention to say, well, it's senior Swiss women who are the biggest sort of victims of climate change, but really to show this is an issue of human rights. It's an issue of all human rights, and we need to identify vulnerable groups, and we need to see how we can use existing legal systems to make those arguments and to really put pressure on governments to, to make sure that they're doing what they've committed themselves to do.
And this was really interesting. Thanks so much for joining us on this episode.
Hi there, listener. Before we continue our deep dive into what matters today, I want to introduce you to another thought-provoking podcast from the Geneva Graduate Institute. It's called the Geneva Graduate Institute Events Rewind, where we invite you to immerse yourself in recordings of our live events covering a wide array of subjects impacting people around the world. From discussions on international law to insights on AI, sustainability, and governance, the Geneva Graduate Institute Events Rewind brings you first-hand perspectives from our esteemed faculty and experts. If you're passionate about staying informed on global affairs and want to hear engaging discussions on pressing issues, then be sure to add the Geneva Graduate Institute Events Rewind to your listening lineup. You can find it on all major podcast platforms, so why wait? Subscribe now and connect to the heart of International Geneva and beyond from wherever you are in the world. Thanks for tuning in. Now let's dive back into our exploration of key global issues on what matters today.
This podcast series is produced by the Geneva Graduate Institute Communications team. For more information about the Institute, please visit our website at graduateinstitute.ch. I'm Dan Graham. Thanks for listening.